state GOP aims to defend Trump's right to be on presidential preference ballot. Phoenix, the Arizona Republican Party wants to defend the right of Donald Trump to be on the ballot in the state's 2024 presidential preference election despite claims by another candidate he is disqualified. Time equals 400 Ms. greater than the party's attorney says it needs to intervene because it cannot rely on Democratic Secretary of State Adrian, who is defending Trump's right to run, to do it as forcefully as possible. The fight playing out in federal court stems from a filing last month by Texas resident John Anthony Castro, who is registered with the Federal Elections Commission as a Republican candidate for president. He claims that Trump is disqualified from running because he provided aid and comfort to an insurrection that mirrors language from the 14th Amendment, adopted after the Civil War. It bars the election to certain federal offices, including president, who has engaged in insurrection or rebellion, or given aid or comfort to the enemies thereof. Castro wants U.S. District Court Judge Douglas Reyes to order Fontes to not put Trump's name on the ballot for the March 19, 2024, presidential preference primary. Fontes already has said he has no legal right to keep the former president off the ballot. He pointed to a provision of Arizona law that says any candidate who files the requisite 500 signatures is entitled to be included on the ballot here if he or she also qualifies for the ballot in at least 2 other states. And the state attorney general's office already is defending Fontes in Reyes court. Not good enough, said attorney Dennis Wilenchik, who is representing the state party. At the very least, he told the judge, Fontes' interest is solely in upholding his interpretation of the law. Therefore, his ultimate objective is both narrowly focused and, of course, is colored by his Democratic background, Wilenchik said. He has no political incentive to pay attention to the specific issues that concern the AZ GOP and its members. That interest, the attorney said, is giving Arizona Republicans access to as many candidates as possible for any primary election, including the presidential preference election. The AZ GOP also has a strong interest in ensuring that its presidential preference elections are fair to all potential candidates and are perceived as such both by registered Arizona Republicans and others. Nor does Wilenchik believe that Trump's own role in the case, he also is named as a defendant, is sufficient to protect the party's interest. He said the former president can't be counted on to care about anything beyond getting his name on the Arizona primary ballot. The AZ GOP, however, is interested in safeguarding fair and fully participatory Arizona Republican primaries and presidential preference elections for many years beyond the impending 2024 election cycle, Wilenchik said. Former President Trump is not situated to make these long-term arguments. The state GOP is taking no position in the new filing on who should be the party's presidential nominee. Trump is one of nearly a dozen GOP contenders with some name recognition who want to be president. What the party is interested in, said Wilenchik, is maximum competition and maximum opportunity for Arizona voters, or, in this case, at least registered Republicans who are the only ones who can vote in the party's presidential primary. Time equals 400 Ms. greater than Wilenchik also took a slap at Castro for trying to force Fontes to keep Trump off the ballot, saying it would deprive Arizona Republicans of their state constitutional rights. The relief sought by plaintiff is a restriction on AZ GOP's speech which is content and viewpoint-based and demonstrates an effort to intimidate and silence the AZ GOP's association and expression, he wrote. Wilenchik acknowledged the language of the 14th Amendment, but he wants Reyes to rule that Fontes does not have the authority, under that amendment, to keep Trump off the ballot. Castro does not agree. And in his 17-page self-filed brief he cites multiple instances of activities and comments by Trump on and around the January 6, 2021, riot in Washington that he said crossed the legal line and make the former president ineligible. Still, Castro conceded the authority of Reyes to keep Trump off the ballot may not be as clear as all that. Time equals 400 Ms. greater than he said he views the judiciary as the ultimate decider of Trump's eligibility. But Castro also said it might take more. A congressional finding of liability would certainly aid the judiciary's fact-finding mission, he said, according to his own bio. Castro's political career dates back to an unsuccessful bid for county commissioner in 2004 at age 19. There also were efforts to get elected to Congress. Now a Texas tax consultant, he filed in March to run for president as a Republican, loaning his campaign $20 million according to records filed with the Federal Election Commission. This isn't his first legal foray into trying to keep Trump off the ballot. Earlier this month the U.S. Supreme Court, without comment, refused to overturn a ruling by a federal judge in Florida where Castro sought similar relief. But that likely does not preclude his case here, or similar ones filed by other groups in other states, from going forward. A trial before Reyes is set for the end of this month. What is NABUR? Join the online forum.